Hello, everyone. Good morning, good afternoon, good evening, depending on the time zone you are in. My name is Maciej Bartkowski, and I'm Senior Director for Education and Research at ICNC. I will be the moderator of the ICNC webinar discussion today. And today I have a great pleasure of introducing Dr. Elizabeth Wilson. And Dr. Wilson is a visiting faculty at Rutgers Law School in New Jersey. She recently served as a Fulbright-Nehru Senior Scholar at the Center for Policy Research in New Delhi, India. And her areas of specialization include public international law and international human rights law. She holds a J.D. from Harvard Law School and a Ph.D. from the University of Pennsylvania. Today, Dr. Wilson will highlight the main findings on civil resistance movements and international human rights norms from her groundbreaking monograph, which was published by the International Center on Nonviolent Conflict, and is available for the download on our website. I will also add that Dr. Wilson is in fact a leading scholar researching international law, international human rights norms in the context of civil resistance and nonviolent campaigns, and looking at how people power movements impact international norms. She has been in this field already for a number of years, and is really the only expert in the world that I know of so deeply immersed in trying to understand and explain the intersection and interplay between movements and international law.
Understanding the impact of people power movements on international human rights. So the basic aim of this monograph is to build a bridge between two fields of practice and research, human rights law on the one hand and civil resistance movements on the other, that currently have little crossover or cross-fertilization. I do this by creating a framework to situate nonviolent civil resistance, or what I'll generally call people power movements, in the context of international human rights law. As things stand now, people power movements are without formal legal status in international law, although certain human rights norms apply to them as well as to individuals. The monograph is structured like a traditional legal analysis and divided into two halves. The first half determines the law by setting out relevant legal scholarship, creating a new multi-dimensional analytical framework, and explaining the theoretical basis. The second half of the monograph takes this framework and concretely applies it in particular situations, unfolding it from one dimension of law to another. Though first and foremost a legal analysis, the monograph will identify a research agenda that social scientists can pursue going forward, perhaps in collaboration with legal scholars, in their work on civil resistance movements. Ideally, it will also aid human rights activists in understanding how people power movements on the ground may work synergistically with international and domestic law to realize and develop international human rights. So I'll start first by introducing the prime actors in international law. These are nation states. And if you look at the image on this slide, you can see the buildings on the side of the Wenceslas Square during the Velvet Revolution. And I like to think of these as representations of states. States are the only lawmaking entities in international law, the only subjects with power to make law, though they sometimes delegate that power to international organizations, and the international organizations are represented by the large building at the top of the square. That could be the United Nations. States make law in one of two main ways: by making treaties with one another, and by engaging in a consistent pattern of behavior with one another known as customary law. Taken together, treaty law and customary law are called positive law because they're tangible, often written and created through social practice. Individuals and groups may be protected by international law, and in the rare case of criminal law offenses like war crimes, crimes against humanity, or ethnic cleansing, individuals can be prosecuted for violations of international law, but they do not directly have the power to make law. So this vast wave of people in the center of the image have no power to make international law. This approach to seeing states as the only lawmakers in international law worked fairly well, so long as international law was mainly concerned with the international relations between states. But international law has increasingly included law regulating how states treat people within their territory, and this has created a problem. So while traditional international law is state-centric and positivist, human rights are usually, if mysteriously, defined as rights that people have by virtue of their humanness. They are seen not as created by either international or domestic law, but as inherent to human beings. But then, where do they come from? They can't come from a treaty or state practice, although they can be protected by treaties or custom. Human rights treaties are at patchwork, with many states not ratifying or ratifying only with large reservations. Human rights customary law is a contradiction in terms because so many states pay lip service to human rights law but violate it in practice. Human rights are often considered a natural law idea. Natural law is an old idea that was common in the early years of international law. It was law that was seen as inherent in the nature of things because it came from the mind of God or the structure of human reason. But natural law has fallen into disfavor since the scientific revolution of the 19th century, either because it is seen to be subjective or resting on a theological framework. But if we don't believe in natural law, where do human rights come from? This monograph offers a solution by reconceptualizing natural law as people power. And I'm going to skip over the analysis I've done of the scholarship that shows how cumbersome and unsatisfying the efforts have been to theorize sources of human rights in traditional international law terms. So the solution I suggest is to reconceptualize natural law as people power, not an absolute term existing in the mind of God or the structure of human reason, but a relative term that reflects a human creative envisioning of an alternative legal order that is being created intersubjectively through collective practices, such as nonviolent civil resistance. Whatever the justification for refusing to recognize individuals as lawmakers in the context of other areas of international law, is peculiarly wrong-headed when it comes to international human rights law. International human rights law did not come into existence top-down out of the benevolent intentions of states. Rather, it came into existence from the bottom-up efforts of ordinary people in civil society to ally with each other in solidarity and demand their rights. Unlike international law generally, the real source of international human rights law has been people power. But we don't have a way to conceptualize this in international law because of the problem that individuals are not lawmakers. So in this monograph, I take an alternative approach to the problem of sources using the third, far less central source of law called general principles. And this gets into a technical analysis of sources of international law, but basically treaty law and customary law are by far the more dominant. General principles are referred to when there isn't a clear source of a legal practice in positive law, but the idea is seen to be logical and necessary, or reflective of principles common to domestic legal systems around the world. There are multiple and conflicting approaches to the idea of general principles, and they are controversial because they're often seen as a way for natural law ideas to sneak in through the back door. So I'm trying to develop an approach to general principles that solves some of these problems. I suggest that we take a sociological approach to natural law. Where there's no law or only bad law, people will have recourse to the tools of natural rights, civil disobedience, non-cooperation, boycotts, stayaways, and so on. Before human rights were positive law, they were imagined natural rights, moral or political ideas that motivated social movements. Abolition, the fight for women's suffrage and equal rights, labor organizing, indigenous peoples' rights. And if you think back to the Greek classic play Antigone, you see the natural rights idea in action when Antigone opposed the edicts of Creon, king of Thebes. Her disobedience was of the positive law in the name of a higher justice. But this law was not mysterious. We could know what she wanted. Her actions that she took were clear, and so were her reasons for taking those actions. So this is a researchable idea. So I'm going to turn to the first half of the monograph and really condense it radically. I argue that it makes sense to think of international human rights as a hybrid form of law in two ways. It's a hybrid of international and domestic law, and a hybrid of positive and natural law, with natural law reconceptualized, as I'm suggesting here. In the monograph, I developed this a little bit more systematically through the creation of two grids that I superimpose on one another. But here I'm just going to show you the final grid and walk you through that a little bit. So this is a diagram of the analytical framework that I've come up with here. And on the right-hand side of the grid, quadrants A and B, these represent the positive law of international human rights. In the upper quadrant, this is the international sphere, and I indicate in the boxes where the law is found, and also some of the institutions that that work with or implement this law. So in the international sphere, we find the law and treaties, customs, and to a much lesser extent, general principles. And the institutions that implement this law are the human rights mechanisms, such as the Human Rights Council at the United Nations and the various treaty bodies. In the domestic sphere, we find human rights most often in constitutions and bills of rights and laws implementing international treaties. And these are looked over and implemented through courts and sometimes national human rights commissions. On the left-hand side of the grid, this represents natural law, people power movements, and how they may be organized in relation to the positive law or the natural law of human rights. And we need to have a concept of a natural law of human rights, because the positive law of human rights, the law on the right-hand side, does not necessarily encompass all the rights that could be and have been claimed by people power movements. Some people think that human rights treaties, for example, are too minimalistic in their aims and should be expanded to truly further human liberation. Some of the rights that are not reflected in state-centric human rights treaties are the right to resist tyranny and oppression, the right to self-determination outside of certain narrowly defined ways, the right to democracy, the right to an accountable government. So in the bottom left-hand quadrant, this represents people power movements that are organized in relation to the domestic positive law of human rights, and that are trying to enact, amend, implement, or enforce human rights laws in domestic systems, or maybe realize additional rights to an accountable government, democracy, and resistance of tyranny. Sometimes, and this is the upper right-hand quadrant, movements will exceed or expand beyond, explode beyond the limits of existing domestic law. And they will become, instead of reformist movements, they will become revolutionary movements that are trying to reorganize the domestic law of the state. And these are often civil resistance movements against dictatorship and occupation or independence. Okay, there's one more step required to complete this framework, and that is to define the specific content of the general principles that apply to human rights law and that function as limiting criteria. Not all movements are human rights movements. Movements can be fascist or exclusionary. In order to create criteria for understanding what movements are furthering the human rights project, we need to define the content of the principles that organize the praxis. Here we can think about the useful definition of a principle as, quote, something which is not itself a rule, but which underlies a rule or explains or provides the reason for it, unquote. And I argue that succinctly, 4 general principles lie at the heart of the Human Rights Project. These are non-discrimination, non-repression, non-exploitation, and non-violence. Most of the important human rights protected in positive law and aspired to in natural law can arguably be understood as emanating from these core principles. I can't explain how I derive them here, but I'll just say a few things about them. Rather than representing a fixed state, particular substantive rights, they are more like vectors that define a direction along which human rights lawmaking activity can be organized. They embrace both rights and duties. The duty of non-discrimination implies the right to be free from discrimination. The duty of non-repression implies the right to be free from repression, and so on. They combine to create a certain basic narrative or ethos that is central to the Human Rights Project, in which human dignity is realized through the means of individual and collective activity organized around these activities, around these principles. So now I'm going to take this framework and apply it to 3 broad types of real-world activities involving people power movements. The first scenario looks at how human rights law may be used to protect participants in nonviolent movements. So here we're looking mostly at the movement from positive law to natural law. So the arrows go from the right-hand side of the grid to the left-hand side of the grid. This is the usual way that international human rights works. The law protects individuals or groups of individuals. For reasons of time, I'm not going to go into this in too much detail, but there are 2 particular documents that I would recommend civil resistors familiarize themselves with. The International Convention on Civil and Political Rights and the joint report of the Special Rapporteur on the rights to freedom of peaceful assembly and of association, and the Special Rapporteur on extrajudicial summary or arbitrary executions on the proper management of assemblies. Sorry about the title, but it's not my title. The ICCPR includes most of the rights that protect those engaged in nonviolent civil resistance, and the joint report operationalizes these norms into recommendations for states on how to manage assemblies. So these are the rights and the articles that are most relevant to most of the most visible forms of civil resistance. And it should be noted that the expressive and associational rights are protected rights so long as assemblies remain peaceful. If those rights are forfeited, but through the use of violence, individuals are still protected by bodily integrity rights, the right to life, the right to freedom from torture, cruel, inhuman, and degrading treatment, and so on. Some treaties allow individuals and groups to bring specific claims to the treaty bodies that oversee state compliance with the treaty in question. Human rights individuals and groups have so far not used these mechanisms extensively with respect to the rights of association and assembly. So this may be an area for potential exploration. The use of these mechanisms could bring greater attention to the demands and plight of the people power movements. There are some caveats. Means of enforcement are weak, so human rights mechanisms are most relevant in regions of the world that have a more legalized human rights regime and or in countries that care about their human rights reputation. The full legal process takes time and there may be a risk of backlash. Swifter legal results may be obtained through the use of precautionary measures, such as are available in the inter-American and European human rights regional frameworks and some treaty bodies. These are like preliminary injunctions in domestic law that try to freeze a situation so that irreparable harm does not occur while the legal process plays itself out. Precautionary measures can be granted in a number of weeks, but again, their utility depends on the state's concern for its human rights reputation. The second scenario illustrates how people power may invoke, appeal to, or organize themselves in relation to positive human rights law. Here we're looking mainly at the line from C to B, and these can be considered reformist people power movements. The simplest and most straightforward way for people power movements to appeal to human rights is simply to remind states of their treaty obligations. Where a nonviolent movement is overtly focused on a right clearly defined in an applicable treaty, it can be regarded as a per se human rights movement. The umbrella movement in Hong Kong that began in September 2014 is an example of a relatively focused campaign that appealed to a specific right, political participation, protected in an applicable treaty, Article 25 of the ICCPR. During demonstrations, resistors invoked the ICCPR, repeatedly tweeting that it must be, for example, it must be realized and is part of the basic law. Another way that nonviolent actors can interact with human rights positive law is by organizing activities around important events transpiring in human rights related legal mechanisms. For example, because of the new structure of the UN Human Rights Council, even countries that have not signed the ICCPR, like China, will have their human rights record reviewed every 4 years under the Universal Periodic Review process. Chinese activists and Egyptian activists have organized activities around these processes, and in the case of Egypt, the activities set in motion events that culminated in the Egyptian Arab Spring protests. People power movements can also pressure states to pass implementing legislation of human rights treaties or to enforce existing human rights law in domestic law. Sometimes activism by civil society groups that began as reformists can set in motion events that ultimately culminate in revolutionary movements. The most well-known example of this occurred in the former Soviet Union after the final act of the Conference on Security and Cooperation in Europe was concluded in 1975. These were known as the Helsinki Accords, and they said that the Soviet Union would respect human rights in return for having the boundaries after World War II recognized. This led over a period of years to the 1989 revolutions. Okay, so what happens when a reformist movement morphs into a revolutionary movement? Here we're looking at the movement from quadrant C to quadrant D primarily. A revolutionary people power movement is almost always organized within the political and physical confines of an existing nation state, but the aim is not to amend or enforce the existing law of the state, but to enforce a natural law right, such as self-determination or the right to resist oppression. If successful, this may double back and ultimately create a new or revised domestic constitution. So that's the dotted line going from D to B. But here things get complicated in knowing whether these large-scale people power movements should be considered human rights movements, since they're not organized in relation to any particular human rights treaty. The monograph then creates a matrix for assessing when movements that assert rights outside of the framework of human rights treaties can be considered as manifesting a human rights ethos. To do this, we need to return to the general principles and ask, how can we say that a movement in question is manifesting a human rights ethos if it's not operating in relation to a specific treaty? So here I set out some preliminary categories that make up an eventual typology of evidence to be used in assessing this question. A wide variety of evidence may be relevant to determining whether a civil resistance manifests a human rights ethos. And I'm only going to give a few examples here, but some of the categories are publicly articulated motives, philosophical reflections and statements by movement leaders, movement signs, slogans, songs, and poetry, movement education activities, and even opinion polling. So, for example, in the case of Czechoslovakia, Václav Havel wrote deep meditations like The Power of the Powerless that were circulated along with his plays in the underground samizdat literature that was passed unofficially and hand to hand throughout the states of the former Soviet Union. These meditations clearly marked the centrality of human rights to his thought and cause. He eventually was propelled into the presidency of the Soviet Czechoslovakia, as it was then called. And so support for him, and this image on the left-hand side of the slide says Václav Havel na hrad, Havel to the castle, meaning he should occupy the Capitol building. So support for him can be inferred in some ways as support for his human rights platform. To the extent that ephemera, sign, slogan, poetry, and graffiti, like the word freedom scrawled on a wall in Tunisia, are expressed, these may provide prima facie evidence that participants are motivated to realize human rights in their struggle. This evidence may be transitory and not created with an intention to affect posterity, but precisely for that reason, it may provide valuable insight into the inner workings of a movement. And the social media capabilities of today make it even more possible to preserve the ephemera of civil resistance movements and to see whether it reflects the principles of non-repression, non-exploitation, non-discrimination, and non-violence. This typology also gives us a way to approach evidence that may be ambiguous or countervailing. For example, government corruption is often a powerful impetus for people power movements. But freedom from corruption is not a right recognized in the positive law of human rights. It is considered a criminal matter, and human rights activists, human rights scholars, and human rights legal theorists don't look at it as part of the human rights legal framework. But a general principle approach would look at anti-corruption people power movements for evidence that they are expressing a demand that can be understood in terms of non-discrimination, non-repression, or the other principles of human rights. When corruption is seen as depriving people of their dignity, opposition to corruption may be seen as conceptually aligned with the right to an accountable government and the rights to be free from exploitation and repression, even if it is not yet a human right to which people are legally entitled. In Tunisia, for example, demonstrators shouted, "Jobs are a basic human right, you corruption mafia," and "No to repression, you government of corruption." This typology is also useful when it comes to countervailing evidence, such as insults, violent iconography, or even death threats. It is not unheard of for elements in a nonviolent movement to suggest that if the nonviolent protest does not succeed, violence may ensue. The maintenance of nonviolent discipline throughout is important for a movement to be said to reflect a human rights ethos, though it should be noted that isolated incidents of violence are not enough to transform a nonviolent movement into a violent one. Assessing the commitment of human rights of a nonviolent movement may also be of interest to participants in an ongoing way. The efficacy of nonviolent movements may attract some participants who are not sincerely committed to human rights in the long term, or democracy, or to power sharing with coalitions that want to promote human rights and a democratic form of government. Nonviolent revolutions may contain Trojan horses, elements that join in nonviolent movements in order to seize power with the aims of ultimately eliminating rather than sharing power with political opponents, or of instituting non-democratic regimes. So now for some conclusions. What can human rights do for movements? They can make people power movements more legible in the eyes of the international community. By this, I mean that the idea of human rights carries a high degree of prestige and respect among scholars, policymakers, and the general public, and has given rise to a broad array of institutions. Civil resistance, in contrast, remains poorly understood. Showing that civil resistance movements can, and often do, manifest human rights principles can lend them some of the prestige of human rights, legitimizing and enhancing their status. When related to specific human rights, their aims can be immediately apprehended. Nonviolent activists may also find that using the discourse of rights is unifying, helping and strengthening their efforts in coalition building across different segments of a society, and may help a movement gather ground. This occurred in communist Poland a few decades earlier, or in recent years in Ukraine. Although grassroots organizations may have good reason to be suspicious of elite-driven civil society organizations, potent synergies can be created when elite and grassroots organizations work in tandem, as was the case in Argentina in the late 1980s and Guatemala in the 2010s. Using the general principles of non-exploitation, non-discrimination, non-repression, and non-violence may be helpful to practitioners of nonviolent civil resistance in strengthening nonviolent disciplines, avoiding Trojan horses, and successfully steering a movement to a more democratic long-term outcomes. Activists may want to make a greater determination to engage in long-term constructive programs such as education and parallel institution building in order to be better prepared should they actually succeed in their campaigns and need to take power. What can movements do for human rights? They can act as an adjunct to legal enforcement. They can be an aid in internalizing human rights law into domestic law. They can play a vital role in realizing and expanding human rights beyond existing legal frameworks. And they can provide a coherent theoretical source for human rights law. A people-powered approach will not solve the problem of a uniform international law of human rights. The patchwork of treaty coverage and gap between state pronouncements about human rights and actual state practice may remain. But looking at people as the ultimate lawmakers of international human rights may go some way towards allaying the anxiety currently existing about the source of this law. We are not losing anything in starting to think of people power as a source of human rights, since we have never had a uniform positive law of human rights to begin with. And by thinking of people power as the true source of human rights, what we fictitiously lose in terms of uniformity, we make up for by theoretical coherence. I have a couple minutes left for a few other takeaways. Civil society practitioners in traditional civil society organizations or NGOs have reasons to become more informed about nonviolent civil resistance. In many countries around the world today, local civil society practitioners are working in difficult environments. Authoritarianism is resurgent. Dictators are learning from one another how to close the space in which traditional civil society organizations operate. this closing space for traditional civil society and the legal space, this is done mainly through laws and by choking off their ability to operate in legal channels, means that human rights defenders and CSOs that work in such repressive environments may find themselves drained of resources, their voices stifled, and their reputations stained. They may find that they will increasingly have to coordinate with activists who employ the lawless methods of nonviolent resistance and perhaps fall back on such methods themselves. The monograph creates an interdisciplinary research agenda for future collaboration between legal scholars and social scientists. Scholars of civil resistance studies can be attentive to evidence that civil resistance movements are manifesting a human rights ethos. Legal scholars can evaluate this evidence and incorporate it into developing and strengthening general principles of human rights law. And finally, the analysis in this monograph gives the international community additional intellectual rationale for incorporating popular sovereignty into the principles underlying the international legal order and creating a demos-centric approach to sovereignty itself. The past 2 decades saw the rise and arguable fall of the responsibility to protect, which was initially a celebrated attempt to reformulate sovereignty in international law and make it more congruent with the view increasingly dominant in domestic legal systems that sovereignty resides in the people. But as should be evident from the foregoing analysis, the idea of reformulating state sovereignty so that it emphasizes the responsibility of the state to protect its citizens still rests on a paternalistic view that state power inheres in the state itself and not in the people. Thank you very much. I'll leave it at that.
Thank you very much, Dr. Wilson. Thank you very much for the very informative presentation. I wanted to ask Dr. Wilson a question with regard to right to assist. There is an ongoing conversation about the possible emergence of the new norm that would facilitate the conversation about how international community can assist nonviolent movements, given the pushback from the authoritarian states about the sovereign rights and non-interference. And some experts and activists would then indicate the need for such a concept like right to assist and right to be assisted. And I wonder to what extent the monograph and the whole discussion that that monograph is advancing may lay the groundwork for then for the discussion about a new norm like a right to assist and a right to be assisted.
Thanks for that question, Maciej. Actually, I've addressed this more directly in another piece that I've written, which is in the book edited by Maria Stefan and Matt Burrows, is Authoritarianism Staging a Comeback, I believe. And I think that where I come out on this is that there is an arguable norm. It's more applicable for non-state actors. They have a greater claim to a right to assist, and arguably it follows from the duty to prevent repression that human rights activists would have a duty to aid other activists. But it gets complicated when states are involved, and there is a principle in international law of non-intervention that says that states should not interfere in the domestic law of other states. And in the case of people power movements, this has gotten very muddied by the allegation by some states that other states have been fomenting people power movements against them. So this works to discredit people power movements as being an authentic expression of the people's will within a repressive repressive state. So I just think we have to be careful about states being involved in that right or claiming that right to assist. It can get very tricky politically.
I wanted also to ask about the reformist and vis-a-vis revolutionary movements and their impact on shaping human rights in terms of judging that impact, both in quality and qualitatively and maybe quantitatively. Which of those movements would have a kind of greater impact on shaping human rights norms, reformists or revolutionaries? And then, depending on the answer, what that would perhaps tell activists in terms of building the movements, and then perhaps identifying the goals for those movements, be it revolutionary or reformists, in the context of either advancing human rights and through doing that, perhaps giving themselves greater chances of creating a truly nationwide movement, because people would be more willing to join those movements who are seen, as you were saying, as having the human rights ethos, and in that sense having a greater appeal to larger population. So again, do the reformist or revolutionary movements have perhaps greater strategic advantage in terms of incorporating those human rights and promoting them, and how would you kind of distinguish between those two, reformist and revolutionary movements, in terms of the impact on human rights?
Well, that's a really great and key question. And I think that the answer is it's complicated. The reformist movements are really useful in terms of like the bread and butter of human rights, realizing human rights norms in domestic spaces, and that's where you get the teeth for the human rights legal framework. It doesn't come from international law. The teeth comes when it gets into domestic law. So that's extremely important in giving the human rights movement teeth. It can be, when movements become revolutionary, there is a risk. You know, things are spiraling and starting to move outside of a controlled institutional or political space. So revolutionary movements are pushing human rights norms to beyond their limits, to encompass norms that are not protected in human rights treaties. But because of the spiraling effect, there is a kind of dangerousness that is created in those revolutionary moments. So I think that really the space for the greatest change, and the change that is likely to yield the most positive results in the long run, is revolutionary change that remains somehow within the context of a controlled political environment. For example, you know, campaigns for accountability that change the political leadership and force out people who have been seen as corrupt, but still kind of maintain the consistent shape of the state, or some broad contours of its existing political system. But I have to think about that question further. It's certainly a key one.
Thank you, Dr. Wilson. I have one participant, Rivera-san, who would like to ask the question. I will unmute you. Please go ahead.
Thank you. I really appreciate this seminar, so thank you ICNC for offering it, and thank you for the presentation. It's been very informative. I want to ask, what do you see going on around establishing the full body of nonviolent actions as a set of human rights? We've spoken about assembly and speech and touched on organizing a union, let's say. But what about further acts of non-cooperation and intervention? I'm particularly thinking about the anti-BDS, boycott, divest, sanction legislation that is currently happening throughout the US, and what you see in terms of this dynamic around protecting civil resistance as a human right.
Well, I'm not an expert on the BDS movement. I have read analyses that persuaded me that it was consistent with the principles of human rights. I had a wonderful student write a paper on that some years back, and it recalls the strategies that were used against South Africa in the global struggle against apartheid. So without being too saying more than that, I think that it is, it is possibly consistent with a human rights ethos.
Hello, Dr. Wilson. I had the pleasure of meeting you in Washington in November, and thank you very much for making me aware of your monograph. And
oh, hi, Lee.
Hi, and for the opportunity to participate in the webinar. It was extremely clear, and I really thank you for that, for condensing such vast content in a short presentation. And thank you for the monograph. I think it's very exciting to engage with this framework. I have a question around the 4 general principles of non-discrimination, non-repression, non-exploitation, and non-violence. And I was wondering if you could expand a little bit more on how one could measure or assess whether these principles are being upheld within a civil resistance or reformist or revolutionary movement. Is there kind of a tool that you might have developed to do this, or that's my question.
That's an interesting idea to develop such a tool. Certainly, I think that while it's not conclusive, it certainly is. I certainly think there are human rights movements that want to be seen as human rights movements. It behooves them to conduct themselves internally in ways that are consistent with their stated external aims. It makes them more plausible, and I think ultimately will strengthen the movement and make it more resilient. A movement that, and this has been this is an ongoing conversation within the human rights tradition. When natural rights were first announced in the Declaration of Independence, all men were created equal, but it wasn't all men created equal, and it certainly wasn't all women. And this has been a struggle, to set in motion a struggle to live up to that rhetoric. Maybe we could talk about what might go into providing a, what was the word that you used, a tool for assessing this. That might get a little too social scientific-y, but something like principles or standards, or a kind of, are you committed to these,
Universal Periodical Review and China. My question is, what role do you see civil society organizations, and I would add also social movements, playing in the efforts to make states accountable for the human rights violations, particularly in the countries that are not signatories to ICCPR, in order to ensure more positive change, mainly again in countries that have poor human rights record, and especially using the means such as UPR?
Well, I'm not an expert in China, but the value of the UPR process is that it is universal, and countries don't have to be, or not necessarily, signatories of the ICCPR. It's independent of the ICCPR treaty. So every country in the United Nations is subject to a universal periodic review, and for a period of time every 4 years, it is kind of on stage and having its human rights record reviewed publicly. The Egyptian activists used this process very effectively by, making sure, and I don't know how this would work in China because of all the restrictions on media, but to the extent that you can make journalistic outlets aware of the process, to to dialogue with them, and to feed reactions to the statements that are made by the state. This was done very effectively, and the activists in Egypt organized like 100-day. There's a period of time between when the report is submitted and the recommendations are made, and when the state decides on how it's going to respond to those recommendations. And the activists in Egypt made this created kind of a calendar for this, and it just so happened that some very sensational human rights violations occurred in Egypt during that time that were really able to be then publicized through the Facebook page that became the flashpoint for the protests there. So, I mean, it needs to be tailored to every specific situation based on what is possible. But that's an example.
How international human rights advance through nonviolent movements can, in fact, challenge the sovereignty discourse that the undemocratic regimes use in order to protect themselves and shield themselves from international kind of pressure for violation of human rights. So how the international human rights norms advanced by those movements can in fact effectively challenge this authoritarian discourse about sovereign rights and non-interference?
Well, as I try to show in the monograph, I think there is a need for a change in the way international law theorizes the idea of sovereignty, because the traditional view is that sovereignty belongs to states as entities in international law. So states are kind of anthropomorphized and made into things that have, the capacity to have their own rights, the right to sovereignty. Another way of looking at sovereignty is that the sovereignty resides in the people. And this is more typically the case in domestic law. This is in almost every constitution in the world, it says that the sovereignty resides in the people. But this is not a principle in international law, and I'm trying to break that down in this monograph and in another piece that I've written, and try to show that people actually are the sovereigns because they create the state and they maintain the state through their ongoing consent and cooperation, which they can withdraw in nonviolent civil resistance movements. But it's very difficult how, in a particular case at this moment in time, how international frameworks can work on states that take that stance.